wonderful Monday. Welcome to the morning show here on Arise News. I'm Rufai and Seyitan.
I'm Adesuwa.
And I'm Tope Akinyode. Good morning.
Let's change the conversation at this time. After spending over 50 days in detention, the convener of Revolution Now protests and the 2019 presidential candidate of the African Action Congress, AAC, Omoyele Sowore, was finally slammed with a 7-count charge bordering on treasonable felony, insulting the president, Muhammadu Buhari, and calling for a revolution.
On his appearance in court, in which bail was granted, the Department of State Security DSS spokesperson Peter Fondia said the agency is yet to receive the Federal High Court order which grants Sowore bail. He also said the court has not followed the due process. However, Femi Falana, human rights activist and Sowore's lawyer, countered the DSS claim of not receiving a court order and said they are lying.
The Publisher of Sahara Reporters, Omoyele Sowore's last appearance in court also came with another bail, but this time the condition of bail must be met before his release. He was remanded in prison against the argument of his lawyer, who wanted him to be returned to the DSS detention facility.
Well, the African Action Congress has called on President Buhari not to allow the country to descend into a state of lawlessness as a result of flagrant disobedience of court orders.
So joining us now is Tope Akinyode, one of the lawyers representing the detained convener of #Revolution Now movement, Omoyele Sowore. He'll be looking at Sowore's continued incarceration and the rule of law against the backdrop of the bail that was granted by a federal high court last week for his release. Tope, let's go straight to you real quickly. What is all of this? Make sense of all of this. You're part of Sowore's counsel. What has been going on?
Well, unfortunately, we are unable to make any actual sense of the whole drama. First, from the arrest, which more is like an abduction, you know, someone sleeping or having a rest time at his abode in the middle of the night, police officers just locked into his room and then dragged him out for no just cause. For days, we didn't know his whereabouts. So, practically, he was abducted. Towards that period again, the instrumentalities of law were manipulated or disregarded. They didn't allow access to his lawyers for some days. He was detained more than 42 hours, which is the allowed time under the law. After that detention, they needed to now go to a court, the Federal High Court at Abuja, to get extension of time for a prolonged order. Apparently, they did that and they got it. But after the 45 days order, and that order had a lifeline, ordinarily ex parte motions or ex parte orders have a lifeline of 7 days. In exceptional circumstances, court will extend the 7 days into 14 days. Now, this is another exceptional situation, and court granted 45 days, expiring on 21st September 2019. After the expiration day, the DSS did not release the person in their custody. Now, after that time, the legal team of Sowore went to court, led by Barrister Falana, and argued extensively that the order has expired. There is no other subsisting order. It must be released. And yet again, the court gave another order, an order that it must be released immediately. Till now, we don't have any information, or it is not within our knowledge that he has been released.
But bail was granted. Have you met the conditions of this bail? 2 shorties, 100 million naira, he must not leave Abuja. There was bail conditions set. Have you met those conditions?
The bail conditions are actually the real issues that we are currently having. Now, don't let us get it wrong. Bail is actually discretionary to the court. The judge has the liberty to grant a bail application. However, when bail is granted, the position of the law is very clear on it, and it's right. Bail application shouldn't be an attempt or an opportunity to punish a detained person. It furthermore shouldn't be such that cannot be complied with. And the court have held so several times. In the case of Adesuwa against the state, the court held that bail conditions must not be unworkable, must not be such that will voice miserable or inability on the defendant to meet the conditions. Now, look at the present economic reality of Nigeria. Nigeria is apparently the poverty capital of the world. And then we have conditions that stipulates that first the defendant must deposit money before the court, 50 million naira. The bail sum itself, 100 million naira, two sureties. Both of them equally must be worth that sum. And both of them equally too must be resident in Abuja. And one must have landed properties in Abuja. So really, I mean, these are not things that we can afford.
So what are you doing about it?
Well,
if you can't afford it, because those are the terms set.
Yes, under the law too, and because we are lawyers, no matter our grievances, no matter our displeasure about the thing, we must follow through the process. Under the law, we are allowed an opportunity to approach the court again and say, my lord, we appreciate that you granted bail in the first instance, and that's very kind of you. However, considering prevalent circumstances, our client has attempted to ensure that the bail terms are met, but is unable to meet the bail terms. For that reason, my lord, can you kindly vary the terms of your bail? If that also is not complied with, you can appeal it.
Because that sort of contradicts what you said initially. You said that since he was granted bail, you don't know his whereabouts, he has not been released. But there was a bail condition that has not been met. And why it has not been met now is because your client has not been able to meet the financial obligations of that bail condition. Those are two different things.
Now, in the first few days, it was held incommunicado. Was why we said we didn't know his whereabouts. Actually, the DSS were even denying that was with them until public outcry mounted against them. I think on Saturday, Peter Fwanya came and said, yes, he's with us. Okay. That was after hours. And that's what I meant by saying it was held incommunicado. We didn't have access to him. Now, the present terms or the present conditions upon which the bail is being granted are the things that's the accounting task we have before us. You see, and we must not get it wrong. The law is this, and the law is straight. Any person accused of an offense, the defendant in any criminal matter, has the benefit of presumption of innocence. And that presumption of innocence guarantees him two rights under the law, under Section 35 and Section 36, Subsection 1. And the two rights are, number one, he has right to his liberty. Why? Because he hasn't been pronounced guilty. Two, he has right to fair hearing, to which case he has right to his lawyers and be able to prepare adequately for his case. These are the rights that are currently being denied to areas we are talking about.
But you as counsel, and I'm sure Seyitan will also want to bob into this conversation, you as counsel, you've had the time to talk to him, to speak to him, to be able to make your case. He's been in court. You guys have been there with his court. He's got a robust legal team. So how is that right being denied? And where is Sowore currently as we speak? Is it still with the DSS?
As we speak at the moment, the court granted liberty to him, or the court ordered that he be reminded at the prisons, pending when his bail application is practiced. That's usually the practice, actually. But Barrister Femi Falana urged the court to allow him to continue to stay in the DSS detention facility, pending when we'll be able to get through with the process. And the reasons are clear. Well, if we have to be sincere, he's more safe with the DSS.
So you think if he goes to the prison, he might be killed or
we may not be able to guarantee. Look, the DSS arrested him in the first instance. They have violated several provisions of the law. They should not turn their negligence or whatever thing is happening to him on another agency of the government. Let us know who to accuse.
Okay, so one thing that I would like to bring the focus on is for every time that we've seen Sowore in public, really for really short minutes, he's very persistent about, what revolution now represents. You've spent time with him. You've seen him. What are his spirits like, waiting on this to be solved?
Very, very, very high. Look, you see, some people are politicians. Some naturally cannot just enjoy an atmosphere of oppression or suppression. And that's just what they do naturally. You see, Sowore as a person is even a journalist. He's a lecturer. So human rights activism is not business to him. It's not what he does so that let us be there. No. So it's just a normal thing to him. His spirits are high. He's not dampened. In court, if you watch the video clip, in court, he insisted and told the DSS, said, we survived it during military junta. We are going to survive it, and that's the truth. Okay. We are going to survive every lawlessness that is pervading this society at the moment. We are going to survive it.
Well, the Attorney General of the Federation, Abubakar Malami, recently, last week, granted the BBC an interview, and he was asked about Sowore's incarceration and trial, and he says the judiciary is very independent and that this administration has been obeying the rule of law, and, you know, they did not take laws into their hands by judging him guilty without a trial. I want to ask you, are you as confident as the Attorney General of the Federation is in the independence of the judiciary and in a fair trial for Omoyele Sowore?
You see, what I know is a court-granted order for the immediate release of Omoyele Sowore. And it is within my knowledge, too, that the DSS refused to grant him liberty. I don't think that is rule of law. I don't think that is rule of law.
Do you believe that this is going to be a fair trial?
Well, I don't want to preempt the mind of the court, and the noble Lord handling the matter. We cannot afford to speak ill of the court, especially because myself, I'm a minister in the Temple of Justice. That being said, we'll put in our best. The law is the law. It's not written by Buhari. It's not written by whoever. The law is right. And so we are going to push the law in court and ensure that we get our rights, the rights of our clients obtained in court.
Okay, speaking about testing this, there was a court order to release him initially. The DSS said they didn't see that one before. They quickly went back to the court and they filed these charges against him, and this has gone this way. So automatically, what are you guys pushing for now? Are you pushing to perfect this bill? Are you taking this bill back, the bill conditions back to them and say, we're going to appeal this bill condition? Or are you trying to say the first order that says, given by Justice Taiwo, you know, should be reenacted and should be brought into the conversation?
Well, the matter already has intricacies. Intricacies due to the lawlessness, like I said, and the despotic leadership we have in the country at the moment, unapologetically. And unfortunately, it appears we are running a military dictatorship in a democracy.
But the judiciary has been said to be independent. In fact, Tanko Mohammed, while they were having the start of the Judiciary Week, recently said the judiciary will be 100% independent. It will not be cowed, it will not be brought down, it will not be trampled upon.
I mean,
so it's
the Honorable Justice of the Supreme Court and the Chief Justice of Nigeria, Honorable Tanko Mohammed, has said the right things. He has said the right things. Now, unfortunately, that was on 23rd September 2019. That's when he made those proclamations. On 24th September, the following day, in less than 24 hours, the court gave an order and said, release this guy. That was the court that even gave an order to detain him initially.
We'll continue with that line of thought. We'll go for a quick break. We'll come back.
All right, okay.
We'll talk more. Still the Rise Morning Show.
Well, welcome back to the Morning Show here on the Rise News. We still have Tope Akinyode, one of the lawyers representing the detained convener of the #Revolution Now protest, Omoyele Sowore. Thank you so much for staying with us. Before that break, Rufai had asked you a question. What your next line of action would be, especially as you are yet to meet the bail conditions? What exactly is it?
We are approaching the court again. Like I said, we are going to approach the court, and the court has been magnanimous enough to grant the bail application, because ultimately to be at the discretion of the judge. The court has exercised its discretion judicially and judiciously, but we are going to press it on the court to consider the prevalent economic realities, the value of which is attached to the bail conditions, and bring it down. Well,
Seyitan had mentioned earlier how defiant Sowore has remained in his appearances in court. And just last Friday, when he went for that bail hearing, he said this, and I quote, "Nigeria is in a situation as it was before independence. We need a brand new country, and that's what I'm all about." Is this different from the rhetoric and the cause of the embattled IPOB leader? There's a nexus here, isn't there?
I don't necessarily think so. IPOB is defending an ethnic group. the call for revolution now is the benefit, or are the benefits that should accrue to citizens in a functional democracy.
But when you say you need a brand new country, what does that mean? And he's been trying to redefine or define, because the bone of contention here is the term revolution, the nomenclature revolution. The government says they're trying to topple it undemocratically. And Sowore is saying it's about changing the ills of society. But when you now say we need a brand new country, where do you find a brand new country? How do you get a brand new country?
You see, let me just say it. We shouldn't be dissuaded by those who have attempted to criminalize the word revolution. And unfortunately, there are people who have limited knowledge or deficient in the lingua franca. They don't have basic understanding of English language. Revolution, the word revolution as it is, can be positive. For example, if you overhaul a system or a sector for advancement or for effectiveness or for better or for excellence as it is, that's revolution. And you see, the person in question has always insisted that he has successfully engineered a revolution in this country before. And if you ask him, he will say in the media sector. And if he says so, don't doubt him. When he came up with Sahara Reporters, they were breaking news. They are breaking news. They are turning the tides around. Information we wouldn't get on mainstream media. That's revolution to the gentleman. And in its right sense, for anybody who understands English language, it's revolution for crying out loud. So now, before something must become an offense, there are provisions of the law. For example, I might say, or the society might say today, we don't want President Buhari again and impeach him. That's a lawful process. Meanwhile, some other people, and we know those who have been doing that before, and whose history we have in this country, can topple the government by a coup d'etat. We know those who have done it. Those who have even done it are the ones now trying to charge people for treasonable felony. Because, you understand?
I mean, yes, definitely. Some would say that Sowore had he contested for the 2019 presidential elections, and he had, a chance to have the Nigerian people vote him in. However, after doing that, he decides to call for a revolution now. I mean, he's a civilian. However, because he has that history, don't you think it came at the wrong time?
He's a Nigerian with rights. He's a citizen. The fact that he contested, there's no provision of the law that says that if you contest elections in these countries, your rights, certain rights will be deprived from you. Example, right of public speaking. Example, rights to criticize the government. Example, rights to hold the government accountable. There are no such provisions of the law that I know. So, I mean, the fact that he ran for election and lost or even won does not say that, does not stop him from holding the government accountable. But unfortunately, we have a very we have a government that cannot allow dissent. You see, these people don't understand democracy as it is.
Okay, let's talk about technicalities of this case. So, I mean, we're trying to get an understanding, and maybe for the benefit of those watching, Justice Taiwo, the ruling of Justice Taiwo automatically now subsists. Can you explain, the legal tangle, the nexus around that area? Okay. Now, what happens? Because obviously the case has moved off Justice Taiwo now to Justice Ijoma.
That's true. Now, this is what happened. When the DSS arrested Sowore, they didn't have any facts. What they just did was they woke up in their room and yawned and said, we want to arrest someone. Let us go and pick Sowore. That's what they did actually. Why? Because when they came to court, after the expiration of the 2 days period that the law allows them, they said, we don't have facts to nail this man. We don't even know what offense we want to charge him for. My Lord, grant us 90 days. Let us go and shop for facts and concoct all the facts in the world to nail this man. Now, the court said, we won't give you 45, we won't give you 90 days. Take 45 days. Go and do your investigation. Come back if you have come up with any fact. They came back and they rushed back to the court to say, let us just charge him for saying that he insulted the president. Something that is not a known offense anywhere in the law in Nigeria. Now, that being said, those things happened at that time because he has not been charged. So he was We can say that he was even being punished in anticipation of an offense because he was being detained while looking for the offense to charge him for. That's what happened. After that order, which elapsed 21st September 2019, the court rightly on 24th September 2019 held that the order I gave was very specific. It elapses 21st September. There's no other order there's no other application before me to extend that time. I cannot extend it. Therefore, release him. So immediately the court granted that release, even if he had been released. If they go back to the court to charge him, and they have the liberty to. If they go to court to charge him again, we will now have to reapply for his bail condition. What we are saying that the people who are even charging him, they lack the moral capacity to even bring him before the court. Because apparently, even if the court declares, and that is rightly the case, because there's no charge against him, at the end of trial, and the court says, go home, we are not sure these ones will allow him to go.
So from there now, what happened afterwards? Obviously, since they recharged him, they took him to another court now. Obviously, Justice Taiwo's ruling doesn't hold water any longer.
Well, not exactly because they went to another court.
Because they charged him now.
Because they charged him.
Now, given the time that has passed and your interactions with him, I wonder if your client ever regrets embarking on this revolution. Failed, lots of people would say, because they had only one day of protest and the turnout was very low. Does he regret? Does he think that he could have done something different?
I would even disagree that the revolutionary protest failed. You think it was
successful?
All the things that are happening now are a clear exposure. They are exposing this government.
Well, it is only him who remains in incarceration.
No, forget about it. Forget about the two of them. The two of them, they are not bothered. What we are saying is this. Okay, look at the revolutionary protest. There were clear demands. They wanted to go to the government accounting for the 30 minimum wage, which the government
it's
had.
Still not been paid.
You don't understand.
So you still think that it is successful?
Yeah, it is, because the demands were actually to impress on the government that you are a failure. Come back to life and deliver the dividends of democracy. Continuously, they are failing. With the disobedience to rule of law, they are failing. So who is at loss? They are at loss because it points to the world. I mean, you needed to see the BBC interview. I mean, we are making a huge disgrace of ourselves among the Committee of Nations.
Did he anticipate this outcome?
You see, when you are making your democratic rights, or you are relying, and that's the right he has, the right to protest. When you are relying on your democratic rights, it is not for you to anticipate whether the receiving party will agree to it or not. Yours is just to say, I'm a Nigerian. I have my rights. Give me my rights.
Okay, other protesters were arrested. I just want to know the fate of other protesters that were arrested. Have all of them been released? Well, during that, because I hear some people have been arrested, and we've never heard their case. It's not been brought to the public light.
Many people were arrested, actually, and were charged to court. Okay. And were in court to defend them.
So how many cases are you looking at now?
We have cases in Osun State, we have at Ogun State, we have in Lagos State. The government is a despotic government. They keep arresting people.
So you've got all these cases running side by side?
Yes. We are very confident.
And what are those people charged for? Still revolution now, protest?
The government, they are inconsistent. And they don't even know what they are doing. They charge them for several offenses. Some, they say they are disturbing public peace. So it's all sort of, in fact, consider that they charge someone for insulting the president as criminal offense. Nigeria. It's shameful. So there's no uniformity in the charges against them. Because they are a clueless leadership. And they are just trying to shop around for offenses that do not exist. So they are trumped up charges, basically.
Right. I mean, everybody will be saying, let's see how this case will pan out in court. I mean,
before we go on a quick break, I just want to ask this, because everybody is looking towards the next appearance of his in court, and Femi Falana has been very outspoken about the next steps that you plan on taking. However, just before you step out, if you could just give us a quick summary of the next steps you are going to take regarding this?
The next step we are going to take is to approach the court first and ensure the liberty of our client is guaranteed by pleading to the court to reduce the bail terms. If that is not meant, we will appeal it again, and we hope, or we are certain, because I mean these are the law is 1 + 1. So we ensure first. That's what is on our desk first, to ensure his liberty first, and then we represent and defend the court.
But what if trial coincides with you trying to execute that and get that done with?
Well, and these are technical matters. All applications must be heard. So if we are trying to sort that with the court now, by appealing to court, by bringing application to vary the bail terms, we cannot proceed to trial.
Okay.
That must be settled first before trial.
It says the law is 1 + 1. Okay, let's hope it's 1 + 1 indeed. Thank you so much for coming on the show
a great pleasure
today, and best of luck with your client.
Thank you.